Good day, everyone. Welcome to Crime Talk. Yes, it is the weekend update, a collection of all the top stories throughout the week, conveniently located in one location right here. You're welcome. Thanks for watching. We'll see you next time. Court today in the Lori Vallow matter. As you may recall, one of the prosecutors had a death in the family, and everybody agreed, the court, the defense, and the prosecution agreed to, have no court today. That's just the professional and, kind thing to do. So, I don't know what you did all weekend, but I listened to the Lori Vallow trial, and I got up to speed on everything. Well, let's just say the weirdness is just absolutely crazy. How do you describe such weirdness other than it's just weird? Who believes this stuff? Anyway, let's give you a quick summary of last week. So we had emails and text messages between Lori Vallow and Chad Daybell as they began their extramarital affair, and where they allegedly are starting to conspire to kill people that are in their way. One of the messages was from Mr. Daybell comparing himself to Harry Potter. He said, quote, "I'm a grown-up version of Harry Potter who has to live with the Dudleys in his little space under the stairs." He wrote that back in July of 2019. "Every few weeks I get to escape and have these amazing adventures with my goddess lover. But then I have to return to my life under the stairs feeling trapped." Yes, these two were completely infatuated with one another and clearly having an affair. We also heard from Miss Vallow's former friend and former fellow cultist, Zulema Pastanis, told the court that there were ritualistic castings and that Miss Lori Vallow and Mr. Daybell performed to drive out demons from the dark spirits. You can't make that stuff up. Now, one of our subscribers let me know that apparently it's not uncommon for people high up in the Mormon church to have interactions with Jesus Christ. In fact, it's expected if you're high up in the church, is my understanding. I take this with a grain of salt, but the person seemed somewhat knowledgeable and said that it is almost expected that the higher-ups in the church have these interactions with Jesus Christ. As you may recall, Lori Vallow said that she was interacting with Jesus Christ. So just letting you know, this is apparently why some of these people believe these things. And when somebody says it, apparently if you've had an interaction or a dream or something with Jesus Christ, that therefore you must, be telling the truth. You're not some charlatan, I guess. Anyway, Zulema testified under oath for the prosecution, and she opened up about Lori Vallow and basically the cult beliefs. We'll talk about that a bit in a minute. We also heard a phone conversation between Mr. Daybell and Lori Vallow, and then her best friend Melanie Gibb, who was on the stand, who also testified for the prosecution. Now, in early December 2019, the call that she recorded surreptitiously, Ms. Gibb delved into the couple's bizarre cult beliefs and later confronted them, asking her to lie to the police about JJ's whereabouts. Now, we heard this at the preliminary hearing, but it just reinforces seriously the consciousness of guilt and the lengths of which Lori Vallow would go to, not get caught or have to explain why her children, JJ and Tylee, were missing and were unaccounted for. And of course, in the other call was the notorious jailhouse call where Chad Daybell tells his new wife, who's sitting in custody, that law enforcement were on the scene and basically getting warmer. Ultimately, Chad Daybell was arrested shortly after the remains of Tylee and JJ were found. Photos shown at the trial also reveal how her slain son JJ was still wearing his red pajamas and a nighttime diaper when his remains were found buried in that shallow grave on Chad Daybell's property. Now, Joshua, or JJ Vallow, was last seen alive on September 22nd of 2019. The last proof of life showed the little boy who had autism sitting on a sofa dressed in a matching set of red pajamas. 9 months later, on June 2020, remains belonged to him and his 16-year-old sister, Tylee, were found buried on the grounds of the mother's new husband's property, Chad Daybell. I know his defense is going to be, how did those get there? It must have been Alex Cox, Lori's brother, who of course killed her previous husband, Charles Vallow, and it goes on and on and on. Anyway, Lori Vallow's former nephew-in-law broke down in tears on the witness stand as he testified about the moment he had to identify the remains of her murdered 7-year-old son. Lori Vallow, as the DA explained in their opening argument, was driven by money, power, and sex, and that led to the murder of the 2 children and the new life that she was going to embark upon with Chad Daybell. Now, we talked about Zulema Pastenas. Well, she testified, and I think the words that could possibly be used to sum up her testimony would be, Anyway, John Thomas began his cross-examination of Zulema, the widow of Vallow's brother, Alex Cox, about 3 p.m., so they didn't have a whole lot of time before the court ended for the day, and he's expected his cross-examination will end on Tuesday. But during the brief time that they were able to conduct the cross-examination, Zulema was asked whether she believed that her work, referring to the castings out of spirits, had a direct effect on the death of Tammy Daybell, JJ, and Ty Lee. And Zulema said, well, not my work, but Chad and Lori's work, yes, it did. And as you may recall, Melanie Gibbs' testimony, she said that Vallow believed they would die if someone's dark spirit had been removed. Zulema was asked, do I believe that evil spirits can be cast out? Zulema responded, yes. She said because Jesus Christ did it in the Bible. She said that she no longer believes the Daybells and Vallow can cast people out. There you go, ladies and gentlemen. Quick recap. There's more. You got to go. We've got the entire audio up. As you may recall, the court limited the audio recordings that can only be released at the end of the day. You have to pay for them, and there's no cameras in the courtroom. Unbelievable to me why the court would not allow that. We really haven't heard anything new other than perhaps the cause of death as it relates to Tammy Daybell, Chad Daybell's wife, that she died of asphyxiation. That's really about all we've heard new. Hopefully this week we'll get into some more new stuff. Take a listen. It's kind of hard to listen to in some spots because witnesses are, pretty bad. But you just got to get through it. If I had a nickel for every time the word was used with Zulema, I'd be rich. Next on the docket, Leticia Stauch, the trial that is still going on. I think we're up to day 9 or something to that effect, but it seems like it's going a little faster than expected. For those who've been watching, you've noticed that Leticia Stauch has been hiding behind the computer monitors at the defense table. She's been there pretty much the entire time. Well, that has changed. According to the court, she is going to sit between her attorneys. Why? Well, apparently she was, maybe communicating with some family members in the courtroom like that, and somebody saw it and took pictures, and now she gets to sit between her attorneys, and if the court sees any other hand gestures, guess what? She's going to be shackled, and if she can't behave in the courtroom, she'll watch from a cell in the courthouse. You can't make this stuff up, ladies and gentlemen. You can't make this stuff up. But yesterday, what took place? Leticia Stauch's daughter testified. Her daughter is Harley Hunt. And her testimony, as it relates to Leticia Stauch moving from Colorado after Gannon vanished, that's where it gets interesting. On the day following Gannon's disappearance, Stauch allegedly asked or made Miss Hunt, 17 at the time, to pick up at various locations in Colorado Springs without explanation. Those items were, for example, Taco Bell, after Stauch was discharged from an area hospital. Ms. Stauch also exhibited paranoid behavior, including a fear that detectives were trying to frame her, according to her daughter. And Ms. Hunt said that despite her mother's behavior and that Gannon's mysteriously vanished under Stauch's care, she really didn't question the defendant as they packed up and left Colorado Springs. She said, I really didn't question her a whole lot, Ms. Hunt explained on the witness stand. I would be told that she was being disrespectful and quit talking back. Sometimes she would even backhand her. So Leticia Stauch would backhand her daughter for asking, hey, why are we packing up and moving? Anyway, according to Miss Hunt, Stauch rented a van on January 30th of 2020 while the search for Gannon was still ongoing. Miss Hunt testified that Stauch wanted to leave the area because she had concerns for both of their safety. Now, Miss Stauch was also upset that Gannon's mother, Landon Hoyt, and her family members were staying at the Fountain home with Gannon's father, Al, during that same time period. Now, Stauch loaded up many belongings on the van, but she didn't see the green suitcase that police would later find Gannon in. Hunt said that she had seen the suitcase previously since it belonged to Al, but she never saw it in the van. Now, Stauch and Hunt stopped at various places after leaving Colorado. Florida was where Stauch rented a room at the Candlewood Suites in Pensacola, Florida. Hunt said she never saw her mother leave the room, and she didn't recall if the van had been parked in a different parking spot. Hunt added that she never smelled anything foul in the van and that Stauch usually had the air conditioner on. Then in March of 2020, police found Gannon's body stuffed inside the green suitcase under a bridge a few miles away from the Pensacola Candlewood Suites. After Pensacola, the pair traveled to Orlando, and Stauch said that she wanted to live there and began looking for an apartment, according to her daughter. Within a few days, however, her daughter said they left Orlando for South Carolina after Stauch became paranoid and believed that the police were in fact following her. Maybe that paranoia was real. Ultimately, the pair ended up in Myrtle Beach with family. That's also in South Carolina. Then on March 2nd of 2022, police arrested Stauch in Myrtle Beach and charged her mother with the death of Gannon. During the cross-examination, Ms. Hunt told defense lawyers that at the time she believed her mother and didn't question her about Gannon during the road trip. The defense attorneys then accused Ms. Hunt of being manipulative for her own gain, referring to a GoFundMe page that Ms. Hunt made after Stauch's arrest. The page indicated that Hunt had lost both parents. The defense attorney told Ms. Hunt that she didn't lose both parents since Stauch is on trial, but Hunt explained that she lost her mother when she was arrested and left her without anything to survive, and her father passed away of a drug overdose back in 2014. Now, Ms. Hunt said her aunt helped her out after Stauch's arrest and even gave her a car, but took the car back and stopped helping her after Hunt gave a statement to the prosecution. The GoFundMe page was subsequently created. The prosecution then did some redirect as it relates to Ms. Hunt and asked if Stauch could pick Gannon up, stuff him into a suitcase, and toss that suitcase over a guardrail. Ms. Hunt said, yes, probably. And Hunt said that she was irate when she learned that her mother pled not guilty by reason of insanity after believing in her mother's innocence for years. She said, quote, "I'm still in shock. I just feel manipulated and lied to," Ms. Hunt testified. "That thought never came across my mind. I just never thought my mom would do that. I didn't see her as the type of person that would do that." She cried, and then her testimony was over. Because remember, ladies and gentlemen, not guilty by reason of insanity. The law in Colorado is it's an affirmative defense. It says, yes, I did it. Hence the reason why the defense attorneys aren't really vigorously fighting a whole lot and are sitting there kind of looking a little bored because they're not disputing what took place. They're just saying we were justified in doing it. That will come out in the defense case in chief. Interesting when their own daughter is shocked. Leticia Stauch's own daughter is shocked that basically she did it after she believed she didn't. Yes, welcome to the world of criminal defense. People tell their family one thing, and then ultimately the truth will come out. Remember, ladies and gentlemen, the truth, or a close version of it, comes out between the beginning of trial and the end of trial. Next on the docket, a little Lori Vallow update. As we noted, we had to get back yesterday, but we were able to fly there and get back yesterday evening. But it was an interesting experience. Ada County there in Boise, very nice, clean city. It almost reminds me of almost Colorado Springs, the way it's kind of nestled right there up against the mountains. Lovely place, lovely people as well. Well, this morning, more Chandler, Arizona officers testified regarding the death of Charles Vallow. Now, the defense had no questions for these witnesses and basically said, we object to all of their testimony because this is 404B evidence. So I thought that this would maybe be a good time to try and explain this again. We've explained it several times, but the question still keeps coming up. Think about it. Lori Vallow has not been convicted of conspiring to kill her husband, Charles Vallow, with Alex Cox. Hasn't been convicted of it. But yet all that evidence is coming in against her, and we'll explain a little bit why. And I'm not sure the judge necessarily got it right, but we don't know, of course, because Judge Boyce has kept everything in private. His 404B rulings, the motions arguing for and against it on both sides, we don't have any information about it. I ask you, what is the big secret? All of this has been released in public information from the Chandler Police Department, but yet I don't think there's anything really new that's come out that the judge is making everything so secret. Anyway, 404B evidence is evidence of prior bad acts that the prosecution can introduce in their case in chief. Now, we'll talk about the federal rule, but most of the states are exactly the same. And it says the prosecution is able to introduce evidence of defendants' prior bad acts that are not charged in the instant criminal case. Okay? Now, although introduction of 404B evidence is not permissible to show the individual's criminal propensity or predisposition to commit crime, 404B is admissible for other reasons. So what does that mean? That's propensity evidence. Just because you have multiple convictions, you've done other bad things, we can't bring that in to say, look, they've done bad things in the past. They must have done bad things here in this case as well. Who knows? Maybe in this particular case, they're completely innocent and they got railroaded because of all the previous convictions. You just never know. So the 404B provides that prior act evidence is not admissible to prove the character of the person in order to show action in conformity therewith, but it is admissible for several other purposes. Specifically, 404B evidence can be admissible for purposes such as showing motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Now, whether to admit 404B evidence is within the discretion of the trial judge, but it is subject to review by the appellate courts to say, hey, this was so prejudicial, it resulted in an unfair trial. Hence the reason why Lori Vallow's attorneys are objecting to each and every one of these witnesses as it relates to the death of Charles Vallow. So the judge has to decide their four-factor test that the court must consider in determining 404B evidence and whether it is admissible at trial. These factors come from a 1988 Supreme Court case called United States v. Huddleston, and then obviously the states have their own case law interpreting those as well. But to determine whether evidence is uncharged crime is admissible at trial, the court must consider evidence of the uncharged crimes was offered for a proper purpose, and it was relevant to a disputed trial issue, and its probative value is substantially outweighed by its possible prejudicial effect against the defendant, and the trial court must administer an appropriate limiting instruction. Now, when you listen to the trial of Lori Vallow, when there is this 404B witness, the judge has issued a limiting instruction saying that, well, you can consider it for all these other reasons. Now, normally, courts are getting away from just saying, well, you can consider it for all of these. Now, at least where I practice in the state court, is that you must be able to articulate specifically under which subsection, not just say, oh, it's all of them, judge, motive, plan, scheme, absence of mistake, anything along those lines. So we'll see if the judge did a good job, but we don't know because we didn't get to see his order. I know, I keep going back to that, but it just drives me nuts. Never seen a case tried in chambers. So the 404B evidence in the case law is developed, basically saying evidence should generally be included unless there is an issue with one of the factors that we outlined above. Now, what is the limiting instruction? A limiting instruction is a jury instruction that the judge reads as part of the jury charge after summations, but before deliberations, that explain that the 404B evidence that was presented by the prosecutor was presented for only a limited purpose. For example, to explain motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. The jury can also get that instruction throughout the trial, either before or after the witness testifies, sometimes both, depending on how often the defense wants it read. The jury will also be told that they are not allowed to consider that evidence as proof of any of the defendant's criminal propensity, right? So doesn't that make a whole lot of sense? Look at this crime that we think they committed for this particular reason, why it's coming in. But don't consider it as to whether they're guilty in this case. Just use it for, was this part of the preparation plan, absence of mistake? Sometimes it doesn't make a whole lot of sense, does it? So just because the prosecutor presents evidence that the defendant committed the prior bad act, and they're not charged in the instant indictment, the jury is not allowed to use these prior bad acts as proof that the defendant committed the crime in the indictment. And 404B evidence can be excluded if the court determines that the factors that we talked about before are not met by the prosecution when they file their motion. Remember, these have to be made pre-trial. The court needs to look at whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice, right? Makes sense. Hey, you're on trial for committing 3 murders. Let's talk about this other murder. Is that propensity evidence or common scheme or plan? Well, usually they have to be so related in the same manner in which they were done. The courts made their decision. Another appellate issue for Lori Vallow, I might add. I've always been a firm believer that if the prosecution had a strong case, they did not need any 404B evidence, because oftentimes 404B evidence can be confusing. It can mislead the jury. It's undue delay and wasting time in presenting a lot of cumulative evidence.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
Next on the docket, Alec Baldwin. Charges being dismissed for now, according to the prosecutor. That's right. Alec Baldwin could face new charges in the fatal shooting of the camera woman on the Western film set of Rust. Prosecutors in New Mexico have warned hours after the criminal manslaughter charges were dismissed. The special prosecutor appointed to the case stressed on Thursday evening that Mr. Baldwin has not been cleared. Their statement came shortly after Baldwin's lawyer said that their client was pleased, and the actor posted a tribute to his wife on his Instagram, thanking her for all of her support over the long 18 months. Now, the prosecutor issued a statement saying this decision does not absolve Mr. Baldwin of criminal culpability and charges may be refiled. Mr. Baldwin had insisted that he did not pull the trigger on the prop gun when it fired back in October of 21, ultimately killing Helena Hutchins. The FBI said that that theory was impossible. However, charges were dropped on Thursday because new evidence showed that the gun could indeed have fired without the trigger being pulled. And the prosecutors confirmed they have obtained new facts about the circumstances around the shooting, which led them to dismiss the existing charges against Mr. Baldwin. Now, the armorer who provided the prop gun to Mr. Baldwin, Hannah Gutierrez-Reed, is still being prosecuted as planned. And over the last few days and in preparation for the May 3rd preliminary hearing, new facts were revealed that demanded further investigation and forensic analysis in this case against Alec Baldwin. That's the official statement from the special prosecutor. Consequently, we cannot proceed under the current time constraints on the facts and the evidence turned over by law enforcement in its existing form. We therefore will be dismissing the involuntary manslaughter charges against Mr. Baldwin to conduct further investigation. Like I said, the prosecutor says it doesn't absolve Mr. Baldwin of culpability and charges may be refiled. Our follow-up investigation will remain active and ongoing. Charges against Hannah Gutierrez-Reed remain unchanged. So what does that really mean? Boy, could the prosecutors in New Mexico look a little more incompetent? I'm not sure it really goes that way. Remember, one prosecutor resigned. The other one that was the former prosecutor became an elected official and basically got kicked off the case. The prosecutor that was handling the case that filed the charges, she appointed a special prosecutor. The special prosecutor has the case for less than 2 weeks, and all of a sudden charges get dismissed based upon some new evidence. It's unclear whether it came from Mr. Baldwin's camp or whether it was their own firearm experts. Now remember, the FBI had this gun for 18 months before they charged it, and now they just happen to figure out that it can go off randomly? What are you doing down there, New Mexico prosecutors? Really? Get your act together. So instead of looking embarrassed and possibly losing in court, the prosecutor dismissed the charges against Mr. Baldwin. And of course, statute of limitations still run. So as long as they charge Mr. Baldwin within the applicable statute of limitation, he can still be charged. Jeopardy would not have attached because he has not entered a plea or a jury has not been seated in his case. Therefore, we'll see if they get their act together down there.